You know, something strikes me as I reapproach the bench for rebuttal. If we could go back to the people who wrote these statutes, far back, not just our Kentucky statute, perhaps as far back as the Talmud, the Ten Commandments, the Bible, and we said to them, what if we could tell you that from years from now, if you do this presumption, we're going to be able to tell you through something called this DNA. We're going to be able to tell you who the real father is. My feeling is, they would say, doesn't matter. So what? Family is the key. You know, Mr. Helmer suggested there was a question regarding the value of the marriage. I would argue to this court that this family perhaps values the marriage more, because going through the wars they've been through with this situation, they've chosen to work it out. They said that the marriage, that entity, as Justice Scott pointed out, is so important, is so critical to these three other children, to us as individuals, that we're going to keep it together. The court's got to remember, at least in my estimation, this is not an illegitimate child. KRS 406-011 expresses and implements a substantive rule of law declaring that it is irrelevant. It is irrelevant for paternity purposes whether the child was conceived or born into an intact marriage, in those cases, regardless of who begot the child. That's where I think, as Justice Abramson questioned me towards the end, that's where the statute says that, in my opinion. As a matter of policy, again, with all due respect to this court, I think the courts must address these issues from the perspective of the child. Not the natural mother, not the natural father. Their interest should be solely secondary. In my opinion, Denzik versus Denzik, in the dissent, it sets that forth.
Counsel, could I just ask you, though, does a paternity determination necessarily mean that the best interests of the child can't be assessed with the biological father at the table, the biological mother at the table, and then, as we discussed in the Court of Appeals in Boone versus Ballinger, recognition of paternity doesn't automatically translate into the conclusion that the biological father is going to necessarily enjoy his superior right to custody. In some cases, he may have waived it by his conduct. So I guess that would be my question to you.
Certainly, Justice Abramson. But as Justice Noble pointed out, we can come up with an enormous amount of factual issues that would change any given situation.
Which is why we need the Uniform Parentage Act, isn't it?
Absolutely. But I would say that this court has got to set a tone, as Justice Scott has mentioned and Justice Cunningham, that we've got to protect the family, that we start with the proposition that family is the basis.
Counsel, let me just interrupt you a minute. Do you agree that the primary rule of statutory construction is once the legislature has defined a term, that they're presumed to have known that they've defined it and they mean that definition when they use the word again in another
No question, Your Honor. When I cited inclusio, exclusio, or our law school, my full use of Latin there, if it was not included, it was excluded, and vice versa.
Counsel, 1 minute.
Thank you. I find it curious, as the court has pointed out, the appellee cannot point to one case in any jurisdiction in this land, not one, where a non-marital spouse has been able to interlope into a marriage to attack the paternity of a child.
Just one last question about that. With our new family court structure, which does include the one judge, one family provision,
Very familiar, yes.
which starts out, of course, with all domestic relations cases, but picks up jurisdiction that was formerly district court, including paternity.
Mm-hmm.
If an action begins as a paternity action, let's say, and the family court judge decides to take jurisdiction of it, is that an interloper?
No, ma'am. Not if it is not a child born to an intact marriage. But I do agree, I would opine that if it is a paternity action attacking the child of an intact marriage, yes, ma'am, I would call it an interloper, an
So
invader.
you'd say that the family court judge then, in that point, should not consider or enact or use their paternity jurisdiction in any way whatsoever, but basically say to this person seeking a paternity declaration, sorry, bub, you're out of luck.
Yes, ma'am, I would, because the person doesn't have standing as a father, or was there a child born out of wedlock? In concluding, I would say to the court, this appellee is not a father. He's not
Is
one
it
of the
better to
fathers.
say you're out of luck or that you shouldn't involve this marriage to start with?
That's certainly a question that could be raised and insinuated by that kind of decision, Justice Scott.
Thank you, counsel.
Thank you, Justice.
Recess court.